Good morning and welcome to our web seminar for the month of March on advanced assessment collection issues. We are glad you're here and hope that you had little difficulty signing in. A couple of initial points as we begin. We're going to be covering a lot of ground this morning. We will have 15 minutes at the end of our presentation for questions. We sent you the outline this morning, and we also sent a couple of articles. Turns out that, luck would have it, we didn't scan the second page of each of the articles. We will be resending those to you after the web seminar is concluded today. With me today, I'm very pleased to have Elsy Dysim, one of our collection managers. Elsy has assisted Common Interest Developments in California for about 20 years, collecting assessments and helping communities make sure they can meet their budgets in that way. Well, this morning our seminar is designed to be more advanced. We're going to touch on a number of topics you can see in the outline. And of course, at the outset, it's all about the money. Many of you remember the movie Jerry Maguire, very entertaining film. And of course, what is the phrase from the movie that resonates when we look at these two photographs? Of course, show me the money. That's what our members expect. That's what the neighbors expect who pay their fair share of the assessment budget. It's very difficult for us in this topic to, on the one hand, as we're focusing on the debtors, to remember that what this is really all about is not the debtors. It's really about the good homeowners that are paying their share of the budget. So let's launch into this. We emailed the outline to you this morning. Hopefully you received it. If you did not receive it, my assistant Sylvia at the email you show on the shown on the screen will be happy to send that to you. We will be speaking for about 45 minutes, and we'll have approximately 15 minutes at the end of this presentation for question and answers. I do apologize to the folks who may be listening to this later recorded, who are today attending the Greater Los Angeles chapter of CAI Luncheon. We did not realize that the conflict was there, and fortunately this will be recorded and available by tomorrow afternoon on our website. Hopefully you will have questions as we proceed. If you have questions, do not email them. Please submit your questions in the GoToMeeting software. You'll see a box for questions on your screen. Type those in. At the end of our session, we will be picking out as many questions as we can, and Elsy and I will do our best to answer them for you. This is not a commercial. Yes, we do have an assessment collection department. We are trying in this session to be purely educational, and we are not going to discuss Richardson, Harman, Ober's approach, its charges, or strategies. We will have a promotional webinar available for those who may be interested in the month of April. That's the last we're going to talk about us. When we address this topic, if we're truly going to be the best managers, lawyers, and board members we can be for our communities, we have to acknowledge the attitudes of the public regarding assessment collection and foreclosure. And if you don't think that this screen illustrates what people think about all of us, then you're not in the same reality that you need to be. It's an unpleasant topic. It's a topic with people in trouble. They're unhappy. They're not paying their fair share of the budget. And now they feel that they're being tormented by their association. Here are some news stories just from the past few years around the country on assessment collection. Here's a horrific story from the state of Kentucky. This story just broke last January. Ingrid Boak had $288 in unpaid assessments, and her home that was worth $120,000 was taken away from her. She was sent nearly 30 notices before it was foreclosed, but of course people don't care about all that. What they're horrified is that an association could take somebody's home for $288. Question in the Wall Street Journal 2 years ago on their online real estate section. A reader asks their real estate advice columnist about her past due assessments and says, "I was shocked to find a notice on my door that the HOA can foreclose on my house," and says, how can they do that? I think we talk about assessment collection. We need to recognize that a lot of folks don't realize that in the state of California and in many states in the country, associations can actually take somebody's home away for assessments. Here's another story from just this year in the month of January. involving foreclosures on homeowner association residences. Of course, the all-star, the one that resulted in a massive remodeling, so to speak, of assessment collection statutes in California was the famous, or perhaps the infamous, case of Tom and Anita Radcliffe in Northern California. They were in an association called Copper Cove at Lake Tulloch in the area of Copperopolis, and they owed $120. The association took their home away from them legally, completely correctly, and it became a cause célèbre in 2004 and 2003 and 2005. And as we all recall that have done this for a while, that's where we got the limitation in the statute that says associations cannot begin foreclosure until the homeowner is 1 year or $1,800 in principal delinquent. Well, as we already are sensitized to this topic, we also need to acknowledge that the economy has changed. It is continuing to change, and things look a lot better. This is a screen from the California Association of Realtors chief economist from last October, one of many slides showing that the real estate market in California has really rebounded, and now 9 out of 10 every transfers of residences in California are so-called equity sales, in which they're not a foreclosure or a short sale. So that's helpful. Elsy, tell us, how has this affected the assessment collection work in the present?
Well, we are constantly seeing that there are receiving more modifications of loans and payoffs for the homeowners association. Unfortunately, there's no set time of closing some of these modifications of loans, but if the associations are willing to work with the owners, they are receiving payment in full, including refinancing and properties which are raising in value as well. We have fast responses from the owners because they actually want to keep their homes. Owners have the ability to go to resources to pay. They're either getting personal loans or they have job stability at this time, which is assisting them in paying off the homeowners association.
All right, thank you. Another issue that we need to address is the applicability of a federal law. We normally think in assessment collection primarily of state law, but we do have to pay attention to a federal law that's been around quite a while called the Fair Debt Collection Practices Act. The FDCPA is a federal law that regulates how third-party collectors deal with debtors. And under the Fair Debt Collection Practices Act, a homeowner association or common interest development associations are a debt covered by the FDCPA. There's no doubt that attorneys are considered third-party collection vendors. So are, of course, companies that are devoted strictly to the collection of assessments for associations. We're all considered debt collectors, and we have to comply with the FDCPA. A question that has been asked a number of times by lawyers in our area of law and by folks practicing, dealing with the subject is whether community managers are covered by the Fair Debt Collection Practices Act or not. We know that the association itself is not a third party. It is the first party trying to collect its debt. The only guidance we have in recent times is from the Ninth Circuit United States Court of Appeals in a case called Dios versus International Realty. This case was decided in 2011, and in that, this was involving a rental manager. The court decided there that the manager was not a debt collector under the FDCPA. However, there's an important caveat. The court specifically decided it on the grounds that what was going on there was the manager was not collecting past due amounts, but was collecting, I guess, deposits and things that were currently or supposed to be paid ahead of time. So under that narrow factual decision, the court said, well, this manager is not a debt collector in this case. They specifically said, however, in their opinion, we're not deciding the bigger issue of whether a property manager is a debt collector when they're collecting past due assessments. I think the safe bet for, for your management companies out there that are pursuing at least part of the debt. I know many management companies will send out their own delinquency notices and will record the lien in the first place before they send it off to a collection vendor. I think that it would be very good to make sure that your work in pursuing past due assessments, even that limited work, comply with the FDCPA. What does that mean, Elsy?
Well, it means that you need to be cautious of when you're contacting the homeowner. You always need to make sure to have your disclaimer or your voicemail language to let the homeowners know that you are collecting a debt. Also, you have to be extremely cautious when you're contacting the owner regarding their debt, that you need to contact them in a reasonable time, and the contact information that the homeowner has provided the association or the management company. Written consent to discuss the debt to a third party is very important. I know third parties contact the management company of the association on behalf of the owners, and we have to be very cautious in regards to receiving written authorization to disclose any information to a third party. We have to also make sure that we do the debt verification if a homeowner requests it, and we always have to conduct ourselves in a professional mannerism, no matter how angry the owner gets with us.
All right, and this is not a resuscitation of everything the FDCPA requires. These are just some highlights. If you're listening to this presentation and your company does participate in the collection of delinquencies, you really ought to perhaps talk to your corporate counsel and make sure that you are complying with the FDCPA. One thing you need to know is that there are lawyers out there who make a living pursuing class action cases on behalf of consumers when they find technical violations of the FDCPA. Well, in collecting assessments, what should you absolutely not do? From time to time, I'm amazed with the creativity of association presidents and treasurers, and even sometimes their managers, in their efforts to collect past due assessments. You're definitely not in a good place if you're going to go knock on somebody's door and confront them with their arrearage. I had one general manager I spoke with a number of years ago. The board of directors was thrilled because he was going personally, he was an on-site manager, he was going personally to the front door of people who were behind on their assessments and was confronting them with their arrearage and asking them to bring the matter current. That's really not a good idea. You're just asking for trouble, and I really think that the proper approach is to pursue a legal process, pursue the process that the law gives you. Don't leave yourself open for an argument that you have created an ugly confrontation or even worse. Sometimes we're asked if associations can cut off people's access to the swimming pool or to the tennis courts. Well, certainly, an association board, in disciplining a homeowner for a variety of reasons, including delinquent assessments, could vote to cut off somebody's access to the recreation facilities. However, you can't cut off their access to their home. So, for example, if it's a gated community, you can't tell the guard, don't let Mr. Schlump in because he's late on his assessments. You've got to allow people to get to their home regardless. So watch out for the creative approaches in debt collection. Creative approaches are often very dangerous approaches. Well, the appellate courts have been active in the last several years in the area of assessment collection. There are three noteworthy cases from recent years. Many of you that follow legal developments in common interest development law have probably heard about these cases. There were two in 2013. One was a case called Multani. The Multani case involved one of the new legislative developments that outcropped or that grew out of the Radcliffe case, and that was that the legislature, in the many reforms they imposed on assessment collection, required that after a foreclosure was completed, that the common interest development had to give to the former owner a notice that they had a right to redeem the property. In the Multani case, there was a dispute about whether or not the right of redemption was actually sent to the homeowner. The association argued that the right of redemption was an after-the-fact requirement that didn't affect the validity of the foreclosure itself. The appellate decision in that case in 2013 said no, the right of redemption is part of the different notifications process, and the association needs to comply with that. Another case similar to Multani in imposing strict compliance with assessment collection procedures is the Diamond case. The Diamond case, Diamond versus Superior Court, was also decided in 2013. This was a case out of Santa Clara, and in that situation the association had made a number of very technical errors in dealing with Ms. Diamond. This was a special assessment, by the way. I think it was just a little under $10,000, and she was late in paying it, and there had been discussion about payment plans and a variety of back and forth. But ultimately, she filed a motion for summary judgment against the association, saying the association had done 4 things wrong, that the association had not sent her a copy of the recorded notice of delinquent assessment within 10 days after that lien was recorded, that it failed to give her a pre-foreclosure notice of her right to demand alternative dispute resolution, that it failed to record the board's executive session vote to foreclose in the minutes of the next open board meeting, and lastly, that they failed to personally serve her with the notice of the board's vote to foreclose prior to commencement of the foreclosure action. Well, the association argued a variety of fairly obvious positions in defending itself, and one of them was, well, this is, we substantially complied. There was no harm done here. And the court said that, well, here's the final sentence that I'll just quote right from the court opinion. We have found no indication, the court said, we have found no indication in the legislative history that the legislature intended that substantial compliance with the statutory notice requirements would be sufficient to protect the homeowner's interest. And so they held that the association violated each of those technical 4 items, and that each of those required that the foreclosure could not proceed, and they ordered the trial court to grant Ms. Diamond's summary judgment motion. So very, very heavy cases, Diamond in particular, in terms of strict compliance with the process. And by the way, that was a judicial foreclosure. Some lawyers have argued that judicial foreclosures are given less strict scrutiny than non-judicial foreclosures. That may have been true in past years, but certainly by the Diamond case it's not true anymore. All right. The last case that was a lot of subject of a lot of discussion in 2014 was the Huntington Continental case. The Huntington Continental case was a case where the homeowner had fallen behind on his assessments. He had a payment plan that he violated, and then finally he tendered a payment to the association that was just enough to get it below the $1,800 threshold for the association to proceed with foreclosure. The association refused the payment, saying you're either going to have a payment plan or you're going to pay it all. And Mr. The homeowner in the Huntington Continental case, his name escapes me at the moment, sued the association, and the trial court and the Orange County Appellate Department and the published decision in the California Court of Appeal all held that the association cannot refuse partial payments. So the result of the Huntington Continental case, Mr. Minor, I think that was his name, the Huntington Continental case tells us that when a homeowner offers a partial payment, whether it's 5 cents, whether it's 50% of the balance, whatever it is, the association has to take the money. You cannot refuse the money. The court did acknowledge in the conclusion of its opinion that this may mean that homeowners might try to play the system to avoid the consequences of the delinquency by continually keeping the principal balance below $1,800. And the court basically said we can live with that. They said that associations have other options, such as taking the homeowner to small claims court for the money, and that their holding was, in their view, appropriate with the existing scheme. So the bottom line is, if your association has been following the old rule or the old practice of not accepting partial payments, stop it right away, because under Huntington Continental last year the association cannot do so. Elsy, how do we deal with partial payments? What are some tips you'd give us on that regard?
Well, Everyone should remember that communication is a big factor. You need to remember that you need to include all parties involved, your management companies, your owners, any collection company that you're using for your delinquencies. Your accounting needs to be accurate every month because it affects the validity of the debt as well. You need to deal you also need to understand that there's a lot of misunderstanding regarding recording the lien against the property to secure the association's interest. The association can still proceed with recording a lien despite the owner making partial payments, regardless if it's $1,800 or a year of delinquency. Also, one of the things you must remember is bookkeeping errors and how the payments are applied. Partial payments first need to be applied to the assessments, late charges, interest, and cost of collection. So it's very important to apply the partial payments correctly. One of the things is that the association can still proceed with obtaining a personal money judgment despite the homeowner making partial payments towards the delinquency.
There are going to be homeowners that play the system, but as we learned from the Huntington Continental versus Minor case, that's just part of the package now. There are going to be some homeowners that just keep under $1,800, and that may be the rare situation where strictly pursuing a money judgment and getting that on their record, on their credit, may be the best way to deal with those kind of folks. I recognize the problem here is that when you pursue a money judgment against someone that the debt is mostly attorney's fees and late charges and collection costs, that judges don't like that. But I think we're all going to have to learn to explain to the judges that there are cases where homeowners are going to be playing the system like the Huntington Continental strategy, and we're going to have to just educate judges about that problem. I don't have a magic answer beyond that. What about payment plans, Elsy? Can you give us some guidance on how to deal with payment plans?
Yes, a lot of these homeowners are requesting payment plans, and there's no actual standard rule of thumb in regards to the association accepting a payment plan, but the board should come up with a reasonable guideline to offer all the owners when they do offer and submit a payment plan in writing. We do request that when a homeowner contacts our office to send a reasonable payment plan. It shouldn't be too long, as it becomes a burden to the association to track the payments, and most associations usually look for 18 to 24 payment plan in order to assist the owners to bring their account current. Also, it's very important to always confirm in writing what the homeowner is requesting. Have them submit a specific request in regards to how they can pay their monthly payments every month. That way there's no misunderstanding between any of the parties.
So the bottom line here is there are no one-size-fits-all answers, right? Elsy, we've got to look at the circumstances of each specific situation.
Correct.
The other thing that we want you to remember is that the association has no obligation to accept any payment plan. Yes, a homeowner can make voluntary partial payments under the Huntington Continental precedent, but there is presently no law requiring payment plans to be accepted. There have been in recent years, at least one I can think of, one piece of legislation that would have required associations to accept a so-called reasonable payment plan. That did not become law.
Right, and one of the things is that if the homeowner is in a payment plan, if the homeowner does default, you should send a notification letter to inform the owner that collection will resume, and the collection can resume regardless if they made any partial payment.
One issue that has come up a number of times, and it actually reached the attention of the legislature in recent years, was the practice of some assessment collection companies requiring the homeowner, as part of a payment plan, to waive the priority of application of the partial payment. As you know, the partial payment is supposed to first go to principal and last to collection costs, interest, and attorney's fees. Well, there are some folks out there that require, as a condition of accepting the payment plan, that the homeowner's partial payments will not go first to principal, but will go to collection costs and the like. That's a terrible practice. I would strongly recommend you not do that. It violates, if it doesn't violate the letter of the law, it certainly violates the spirit of the law, and it doesn't bring any good credit on our profession or the industry of common interest development management. So I would strongly suggest that if your vendor suggests that you do that, you tell them, no, that's not fair. We're going to follow the law and apply payments to principal. Well, governing documents can help us or hurt us. What are some things that we can do with our governing documents? Well, modern governing documents these days, or amended documents, often will contain an assignment of rents provision where a delinquent landlord will contractually assign their rents to the association, so that if they fall behind in their assessments, the association can go to the homeowner and demand that they pay the rent directly to the association. Some associations also amend their bylaws to require that as an eligibility criterion for board services that you have to be current in your assessments, and that if you become delinquent, that you cannot continue to serve on the board. Another practice that is not usually found in the governing documents but is covered in the Corporations Code is that the association board can hold a hearing to suspend a member's voting rights. And that is a procedure very similar to the normal disciplinary hearing process. The time interval is a little bit different, though, because you have to give the homeowner 15 days advance notice before the suspension can take effect. So if you're going to follow the normal disciplinary timing, which is 10 days prior to the hearing, if you plan on suspending their voting rights at the hearing, you've got to give them 15 days notice, or that suspension cannot be effective until 5 more days. And that comes from the Corporations Code, not from the Davis-Sterling Act. Also, sometimes our governing documents can create problems for us if they're outdated. Elsy, how does sometimes that come into play?
Yes, when we're actually looking at the association's governing documents, we do come across that some of the association's governing documents are not updated in regards to they're collecting not a small amount of late fees or interest rates. For example, the association can be collecting $5 late fees or a 7% interest rate when they could actually be collecting 10% or $10 or up to 12%.
Another couple of another thing that associations can do is, of course, you're required by law to have written assessment collection policies. That's been the law for quite a few years now. Those written assessment collection policies are required to be part of what's now called the annual policy statement and distributed to members each and every year. Elsy, what should those policies contain?
The policy should contain a clear timeline of actions, what the association is going to do, and inform the owners of their timeline. They should enforce the collection policy guidelines effectively, and they should pursue any delinquency promptly and follow those guidelines of the association's collection policy.
An association collection policy also hopefully can be as close to autopilot, at least during the initial stages of the process, as possible. And by autopilot, what I mean is that the decision to impose a late fee, the decision to send a pre-lien notice and to record a lien, those should be set forth with specific timelines in the association's assessment collection policy. The reason for that is you don't want the board to have to worry about it, think about it, discuss it. You want it to be as close to automatic as you can. You don't want the situation where you're looking down in the audience at a friend of yours who unfortunately is the subject of a lien vote that evening. If it's automatic, if everybody understands this is just how we do things, there's no real discretion involved, it takes a little bit of pressure off the board and also the manager as you move forward. Now, when I say autopilot, I mean only up to the point, because the decision to foreclose, whether it's happening with initiating a non-judicial foreclosure or whether it's happening in the context of a lawsuit and asking a court to take somebody's real estate, that is not an autopilot decision. And all the time I get stories from managers and boards where they've gone through and taken somebody's property and nobody ever really stopped to ask why. please don't pursue that decision on autopilot. But I'm referring to the initial stage of the collection process. Also, your assessment votes, your lien vote that's in open session, your foreclosure vote that's in closed session, those can be on your consent calendar. There's really no reason to have separate motions for all of that, and that'll save some time as well. All right. Well, there are two main systems of collecting assessments in California. There's the non-judicial approach and the judicial approach. We're also going to talk in a moment about small claims court. But let me just quickly compare and contrast the two approaches. Certainly the non-judicial approach in California is by far more common. The judicial approach and the non-judicial approach are both the same up to the point after the lien is recorded, because where the two approaches diverge is what you do to enforce the lien. Now, foreclosure, and this is where the two approaches diverge, this is for the minority. This is for the harder cases. Most assessment collection matters resolve before you get to the decision of having to foreclose. But let's talk about that when we get to that point. The non-judicial system is attractive because it doesn't involve courts, it doesn't require attorneys, it often can cost less, and it's an automatic process. You follow the deadlines, you do the notices properly, and if all goes smoothly, the foreclosure happens about 5 months after the lien is recorded. And unless the process is stopped at some point, the end point of this is the association owns the property formerly owned by the homeowner. So that's the attraction. Is it's simple, it's automatic, attorneys and courts aren't involved. The judicial approach involves filing a lawsuit. In that case, the lawsuit is asking for two things, both a judgment for money and to take over ownership of the property. In judicial foreclosure, of course, by definition, the association as attorney is involved. An uncontested lawsuit, interestingly, can proceed more quickly than a non-judicial foreclosure, because in an uncontested lawsuit, once you serve the debtor, the default is taken after 30 days. And once the default is taken, then default judgment papers can be put in, and it's just a question of processing them through the court clerk. So the waiting times that are much longer in non-judicial foreclosure are actually not present in the judicial foreclosure approach. We just have that 30 days in the uncontested situation. Another characteristic of judicial foreclosure is that if there's not enough equity in the property, the association is not out of options. It can still continue to pursue the case and seek a money judgment which is good for 10 years and actually can be renewed for another 10 years before it expires. Another factor about judicial foreclosure is that the unsophisticated owner understands what a lawsuit is. A lot of citizens do not realize that the law allows the association to take their home away from them. But they do understand when they get a summons and complaint. They know that's bad and they need to do something about it. On the other hand, the sophisticated owner, the one who, particularly during the Great Recession of the last 5 years or so, they played the game. They knew that the association, if it foreclosed on their upside-down property, they knew that the association, if it pursued non-judicial foreclosure, could not pursue them for any deficit. So what many of them would do is they would simply play out the string, and they would allow non-judicial foreclosure to take place, and either the bank took it or the HOA took it, and then they moved on to whatever they would live in next. The sophisticated owner, though, when they are presented with a summons and complaint, they understand, wait a minute, this is not just losing the property. I'm at risk of having a judgment that's going to show up on my credit that could affect my bank account in the future, and it certainly cuts a little bit of that game away. The other factor that's different in judicial foreclosure is that when a homeowner is going to dispute the matter, when a homeowner is going to fight, in a non-judicial context, their only option is to file a lawsuit against the association and the foreclosing company, and usually the management firm as well, seeking an injunction against all parties to stop the collection process. In a judicial foreclosure context, that's not necessary. If a homeowner decides to lawyer up and fight the debt, they don't have to sue the management company. They don't have to sue the law firm that's pursuing the case. All they have to do is respond and answer the complaint and say, no, they don't owe the money. So those, I think, are the highlights between the two. The bottom line in the comparison is that non-judicial method can be less expensive. It isn't always, but it often is. And secondly, that the judicial method provides the association with a powerful additional source of repayment, the money judgment. And of course also from a risk management standpoint, that management is far less likely to be sued if the association member decides to dispute the debt. There is one other major method of pursuing collection, and that is small claims court. Small claims court process, of course, has a number of advantages, but it has some limitations as well. The maximum association claim is limited to $5,000 twice a year. So if your assessments are higher, or if this has gone on for a while and the principal debt is beyond $5,000, you're going to not be able to pursue the entire amount in small claims court. If you have a significant number of delinquencies, the third and additional claim in a year is capped at $2,500. Another oddity of small claims court is that while the association can sue for only up to $5,000 for twice in a year, the homeowner, as a human being, as an individual, can countersue or sue in small claims court for up to $10,000. So you could have the crazy situation where the association is suing somebody for $2,500 in assessments, and the homeowner countersues for up to $10,000. Of course, in small claims court, the primary attraction is that attorneys are not allowed. Small claims court only awards money. They are not allowed to act on the lien, so they can't handle foreclosure. And in small claims court, the defendant can appeal, but the plaintiff cannot. So if you don't like your award as plaintiff, you have to just deal with it because you're not able to appeal. The bottom line on small claims court is that it's inexpensive, but it's limited. Sometimes foreclosure is a bad idea. And I made a reference earlier to the fact that you don't want to have automatic pilot attaching to this decision. I, not so long ago, spoke with a friend who was managing a community that had recently hired our firm, and one of the questions I was asked was, well, we have several condominiums that the association owns. And I said, well, how did the association acquire ownership? Well, we foreclosed. I said, oh, okay, so was there equity in the condominiums? The manager said no. I said, well, why did you foreclose on the condominiums then? Well, because that's what we were supposed to do. And now the association was stuck having to pay the expenses on these condominiums until they can sell them. Foreclosure is not always a good idea. Sometimes you don't want the property. You may not want the property because there's too little equity. I'll tell you, there's another circumstance where you may be very unwise in foreclosing, and that's when there's too much equity. There are from time to time situations where somebody just doesn't understand what's going on as a debtor, where they're infirm, they have emotional or mental issues, and they're unable to respond to the debt. And every so often you're going to have a situation, managers, lawyers, directors, where there are several $100,000 of equity in the residence, and you're looking at non-judicial or judicial foreclosure for $10,000 or $15,000. We really need to back up here and look at the bigger picture, because that's when we're getting these media stories that are so devastatingly bad to all of us. Sometimes we need to step away from the automatic pilot and ask, is there any other method than simply taking the property away to make the association whole? One time not too long ago, a board came to me with this exact situation. There were hundreds of thousands of dollars of equity. The homeowner had a history of emotional problems, and periodically over the many years, a homeowner had stepped up. It was somebody she trusted, and they would catch up the arrearage for her, and then she would pay that person back. So I asked the board, well, why aren't we doing it this time? And nobody really could answer the question. So sometimes there are creative ways that we can avoid imposing the disaster on somebody of taking away their residence for a few $1,000s when there's a lot of money. When there's too little equity, that's something that associations, whether it's non-judicial or judicial, there needs to be some thought given to, is there an economic reason for pursuing foreclosure? Particularly in the non-judicial approach, where if you complete it, you are not allowed to proceed against the homeowner for $1 more for the property. You can only take the property. So how do you figure that out? Well, certainly there are somewhat easy and not terribly accurate sources like Zillow. You might be able to run a title search and see what kind of mortgages or liens, judgments are against the property. But think about, is there an economic reason, is there an economic benefit being conferred on the association by consummating this foreclosure? When you think about a situation where the property, let's say the property is $10,000 to the good. You think there's $10,000 positive equity if the property is sold over the mortgage and the liens and whatever else is encumbering the property. Well, depending upon circumstances, that probably is not enough money to justify foreclosure, because you're going to be paying a broker 6% to sell the property. You're going to be paying escrow fees. You're going to be paying maintenance. The buyer of the property may have things that they want the association to do in terms of repairs to fix the property. You may have to evict the tenant. There may be a number of things that the association has to do that are going to wind up actually being further out of pocket. So I can't give you a hard and fast rule. Sometimes I throw out a number of about 10%. If there isn't at least 10% equity in the property, by the time you sell it, you may not be coming out ahead. So I'm not saying don't do it. I'm not saying do it. I'm saying slow down and ask questions and think. Is there really enough equity that the association is benefiting? Or maybe that's a classic situation where they're wasting money on the foreclosure process and they need to focus on a money judgment. Moving along to short sales. It seems like everybody's everybody's been learning a lot about short sales the last 5 years. Elsy, can you give us some guidance on what questions to ask in that regard?
Once you're contacted by an agent or an escrow indicating that there's a short sale pending against the home, you definitely want to ask them whether or not they're going to request for any reductions for the association's consideration, in order to have them submit their request in writing in a reasonable time frame. Also, you want to request for a copy of the HUD-1 for the board to review in regards to that.
And here's the HUD-1 up on the screen. This is a sample. One of the things that you can look at is, I want to make sure that everybody's losing the same. I don't want a situation where the first mortgage holder is taking a 10% reduction and the broker is taking a full commission, and then they're asking the association to take a 50% reduction. As a rule of thumb, what I want to see is that whatever percentage everybody's taking off the normal debt, and that includes in my book the realtor, is everybody taking the same pro rata reduction in what they owe. I know sometimes realtors will try to strong-arm the association and say, well, you have to do this or you're going to lose everything. Well, that's true. That's a risk. I know there are also situations where boards will get aggressive and say, wait a minute, we've got the real leverage here because we can stop this short sale from happening. I think a reasonable middle ground is, look, we're all going to lose a little bit, but maybe it's smarter to take the sure thing and take a slight discount or even a significant discount rather than get nothing and continue to dispute. All right. Then there's the strategy of we're going to rent it out a while. Some associations, when they foreclosed on a home, they'll say, well, we'll continue to have the tenants in the residence and we'll offset some of our debt by collecting rent from the homeowner. Well, the problem there is that most of the time the whole reason the original owner left it was because in addition to the assessment lien, there was also a mortgage. And the California Civil Code requires that if you take over a property and in the first year you aren't paying the mortgage, that is technically called rent skimming. Now, here's the risk. Rent skimming is technically could be the basis of a lawsuit. If you rent skim a certain number of times, I think it's 5 in a year, you could even be committing a misdemeanor. Now, what is the odds that Citibank or Wells Fargo is going to come after the association for doing that? I really don't know. They're probably not very significant. My point, though, is, do you really want to take the risk, and is the benefit of acting as a landlord really worth it? You're an association. You're a nonprofit corporation. You're not a landlord. You're not a rental company. And I just think it's a bad idea to take on this additional role. The money ultimately may not be worth it. But you hear some people saying, don't worry about rent skimming. It's not really a concern. Other people say it's a terrible concern. As with most situations in life, it's not likely to happen, but if it did happen, it's a bad enough result that it might be worth avoiding. But the bigger issue that's certainly a much more likely result is, if you're acting as a landlord, you're going to take on all the headaches and risks of being a landlord and dealing with tenants. So think about that before you jump into a rental relationship. Okay, we've got a judgment, either through small claims court or judicial foreclosure. What the heck do we do with it now, Elsy?
Well, the great thing is that the association has options. They either can foreclose or they could pursue the money judgment. Regardless, we always obtain an abstract signed by the judge through court, and we always record it in the county recorder's office where the owner has the property, and where any other counties where the owner has assets as well, to ensure that the association is secured. The options are, if the association wishes to pursue foreclosure, is that we will get a writ of execution and forward the file to the sheriff's department in order for them to start the foreclosure proceedings. But with the money judgment, we could also request for an asset report to locate bank accounts, employment, and other assets for the owner, including wage garnishment as well.
Sometimes you're going to deal with an out-of-state debtor, and that may require hiring local counsel who's familiar with the laws in that state. There's a lot that can be done, and frankly, post-judgment collection work is not only done by homeowner association attorneys. There are a whole division of law firms that they specialize in collection of debts and collection of judgments. Some of them charge fixed fees, some of them charge a percentage, some of them charge hourly. But the money judgment is a powerful tool. When that abstract of judgment is recorded in a county where somebody owns real estate, that creates a lien on that person's real property that's going to have to be dealt with at some point. So there are quite a few options that the association has in enforcing the judgment. Again, as with anything, you have to look at cost to benefit. You're not going to spend $3,000 having a marshal sit at the person's business watching the cash register if the debt is $500. On the other hand, if it's a huge debt, if it's a $100,000 debt, it might be worth putting a marshal in place for a number of days to do something like that. So, as with everything, you have to look at the problem and find a solution that fits the problem and is warranted by the cost involved. Well, that concludes the prepared part of our presentation today. We're going in a moment to open it up to questions. You have a question box in your screen that you can ask questions, and I see we've already got a number of people that have been doing that, which is great. On April 16, Thursday at 11:30 a.m., we're going to have a 30-minute webinar. This is a promotional webinar. This will be talking specifically about what Richardson, Harman, Ober does in assisting associations with their assessment collections. We will be discussing the specifics of how we pursue the program. We'll be talking about costs. We'll be talking about our dedicated website, rhocollect.com. So we will be sending out a notification on that. If you're interested in that, we'd love to obviously present what we do to you. Our next webinar will be on May 21st. That is a Thursday, we checked, and it's not conflicting with any CAI luncheons. This will be a presentation on fair housing and the homeowner association. Fair housing is a big topic this year. The Fair Employment and Housing Council is in the process as we speak of crafting for the first time, I think, in the United States of America, state regulations implementing fair housing. So there's a lot in flux right now, and there are a lot of issues that managers and lawyers and homeowner association directors need to be aware of. So we hope that you'll be able to participate in that and tell your friends. That's May 21st, Thursday at 11:30 a.m. Well, now's the time. We've set aside about 15 minutes for questions. We'll do the best we can to answer the questions. We will not announce your name. We'll just say your first name. And use the questions button on your computer screen. Please do not use the chat button. That is hard for us to respond to. We have a number of questions already, and I'm going to expand the screen here so we can see those. And all right, I do apologize. We had some comments about sound levels. We're going to work harder on the sound levels next time. Hopefully that was not an impediment to your enjoyment of the seminar. Well, a question from Kim is, how do we collect fines when homeowners refuse to pay them? Well, there really are a couple of techniques. Most association documents do not authorize the imposition of a lien to enforce a fine or a penalty assessment. Interestingly, the law doesn't prohibit documents from allowing a lien to be recorded. It prohibits the association from pursuing non-judicial foreclosure on such a lien. So one thing that can be done in your governing documents is to allow these, obviously this is an amendment that the homeowners would have to vote on, but you can amend the documents to allow a lien to be recorded to secure an unpaid penalty assessment or fine. You've got to be careful though, to make sure that in that same provision you make it clear that the association will only pursue that on a judicial enforcement technique. You can't non-judicially foreclose on that fine. So the bottom line is you're going to be pursuing a judicial action if somebody refuses to pay fines and it goes on for quite a while. Another technique is, of course, a suspension of homeowner amenity rights, homeowner voting rights. There's one association that I worked with for quite a while where the most effective technique they had was cutting off people's cable television. It was amazing how powerful that was. People have a right to their utilities, but they don't have a right to watch HBO. And so one association is very successful today using that technique. So Kim, hope that's helpful. Question from Scott. Can you request that dues going forward are kept current while in a payment plan? What do you think about that, Elsy?
Absolutely. One of the provisions that we tell the homeowners is that not only are they paying their arrears, but they also have to maintain current during the duration of the payment plan agreement between the owner and the association. So yes, you can ask them to send their monthly payments along with payments for the arrears.
All right. One person noted that they did not receive the outline this morning in their email and asked if we could please send a copy. If you'll email me or Elsy or Sylvia, we'll be happy to email you the outline from this morning. David asks, please explain the single action rule. That's a great question. That relates primarily, David, to non-judicial foreclosure. What it means is that in California, the law says that if you pursue non-judicial foreclosure to its completion, that is that's your sole remedy on that arrearage. When you find out that the condominium is not worth anything and the association of foreclosing has received no money, you're not allowed to go ahead and file a separate lawsuit against the homeowner for money. That's why it's really dangerous to go too quickly with non-judicial unless you're sure there's equity on the other side. All right. Question from Deirdre. Can you shut off their water for non-payment of water if the association pays the water bill? Well, Deirdre, no, you can't. That would certainly be very effective, but you can't withhold from anybody the basic necessities of life in their condominiums. So their electricity, their heat, their gas, their water, their trash, those are basic fundamental services I don't think that you'd be able to do. So sorry about that one. We're not able to touch that. Renee asks, if the CC&Rs state that the late fee is $15 a month and the law says it's 10% or $12, can we charge $15? Elsy, what's the maximum late fee we're allowed to charge?
The association can only charge 10% of the monthly assessment, or $10, whichever is greater. If your CCNRs are indicating that they're $15 and that's above the amount, 10% of your assessment, you probably should consider having them amended.
Yeah. The answer to the question really depends on if your assessments are $200 a month, then $15 is fine. Actually, it may be too little because 10% would be larger. So it really depends on what your assessments amount is. Okay. Paul comments, the reason I'm not fearful of rent skimming is because the association is not a party to the mortgage agreement. Well, the problem there, Paul, is that that the statute does not require that the association be a party to the mortgage agreement. The Civil Code statutes 890 through 892 specifically talk about someone taking ownership in the first year and not paying the mortgages on that property. And I think that's exactly what it's pointing to, is people who are not parties to the mortgage agreement and using that as an excuse to not pay the mortgage lender. Again, I can't begin to estimate, the percentage of risk involved. I just think at the end of the day, with the complications of being a landlord, it's probably not worth it. Let's see. Okay, a question from Paul, a different Paul. Assignment of rents in CC&Rs. Can the demand be made directly on the tenant as opposed to the homeowner? And the answer is yes. That's the whole point. In an assignment of rents provision in CC&Rs, the landlord is pre-authorizing the association to make that demand to the tenant. Now, I think that it's a good idea to make sure that if you have that in your CC&Rs, you have landlords and tenants sign an acknowledgement along with the lease agreement that they're aware that there is an assignment of rents provision, so that the tenant knows that that is something that they might be asked to do in the future. Interestingly, when I'm dealing with the amendment of CC&Rs, it's pretty rare for landlords in communities to oppose the assignment of rents. They're usually more concerned about rental caps or percentage limitations, things like that. Okay, question from Karen. Do you need to put an HOA foreclosure that was voted on in executive session? Do you need to put that in the recap in the next regular minutes by the assessor's number? And I think, Karen, the approach is you don't have to necessarily name the homeowner in the minutes. You can use their assessor's number. We often assign a specific number to each account, so that from the very beginning of the lien to the end, it's referred to by number. If you use assessor parcel number, that's an acceptable way of doing it. And if somebody really wants to sleuth it out, of course, they can look up the APN themselves on the internet. But at least it's a way of trying to protect people's dignity a little bit. All right, let me see. I think we have time for just a couple of more questions. Question from Joe. If the owner is delinquent, can the board refuse to approve architecture requests? Wow, that is a really interesting question, Joe. I don't think so. I think that architecture requests need to be considered on their merit or lack of merit. I suppose that you could have an amendment to your CC&Rs that specifically say that architectural modifications will not be allowed for delinquent homeowners. I've never seen that, but I think that at minimum you'd need to have it in your CC&Rs to do something like that. I'd really rather see the association be very diligent on its assessment collections and pursue some of the basic normal responses to delinquencies, and most of the time that's going to help you more than anything else. All right, let's see. We've got a ton of questions. I really apologize to the many of you who have asked questions that it looks like I'm not going to be able to get to, but let me see if I can grab some more. Jan asks, the board does not want to foreclose on delinquencies because the delinquent accounts are only $2,000 to $3,000. It appears small claims court is our only recourse. Is that correct? Well, it's not your only recourse, Jan. It is certainly a very logical recourse because if the account is just barely over that $1,800 limit, the perception may be that it's not worth pursuing judicial or non-judicial foreclosure because of the extra cost that will double at least the principal amount of that debt. Small claims court certainly is a logical choice, and another approach would be a judicial foreclosure or a money damages claim, so that if they pay the amount below the $1,800, like Mr. Miner did in the Huntington Continental case, the case still goes forward for the amount to conclusion. All right. Question from Jessica: can you take a homeowner to small claims court more than once? Certainly you can. If somebody becomes delinquent repeatedly, you get a judgment for one delinquency, they become delinquent again, you can certainly pursue another small claims court judgment after that. All right. I so much appreciate the many questions that were asked today. I apologize. There are a couple of dozen questions it looks like we're not going to get to this morning. I do hope you found this helpful. The seminar will be posted on our website sometime tomorrow afternoon. It should be available. If you go to our main webpage, rhopc.com, you'll see it's not resources, I just blanked. There's a tab where you can click down and it will have webinars, and you can look at this and the other prior webinars that we've had. I very much appreciate you attending. I hope you found it valuable, and we'll look forward to hopefully talking to you in May on fair housing. Thanks all.